We're going to read from 12 CFR 1026.15, right of rescission, re-edited by Noble, sent on Jason L. Copyrighted A. Right to rescind. 1. Except as provided in paragraph A1-2 of this section, in a credit plan in which a security interest is or will be retained or acquired in a consumer's principal dwellings, each consumer whose ownership interest is or will be subject to the security interest shall have the right to rescind each credit extended made under the plan when the plan is open, a security interest when added or increased to secure an existing plan, and the increase when credit limit on the plan is increased. As provided in Section 125E of the Act, the consumer does not have the right to rescind each credit extension made under the plan if such extension is made in accordance with a previously established credit limit for the plan. 2. To exercise the right to rescind, the consumer shall notify the creditor of the rescission by mail, telegram, or other means of written communication. Notice is considered given when mailed or when filed for telegraphic transmission, or if sent by other means, when delivered to the creditor's designated place of business. 3. The consumer may exercise the right to rescind until midnight of the third business day following the occurrence described in paragraph 8.1 of this section that gives rise to the right to rescind. Delivery of the notice required by paragraph B of this section, or delivery of all material disclosures, whichever occurs last. If the required notice and material disclosures are not delivered, the right of rescission shall expire 3 years after the occurrence giving rise to the right of rescission, or upon transfer of all of the consumer's interest in the property, or upon sale of the property, whichever occurs first. In the case of certain administrative proceedings, the rescission period shall be extended in accordance with Section 125F of the Act. The term material disclosure means the information that must be provided to satisfy the requirements in 1026.6 with regard to the method of determining the finance charge and the balance upon which a finance charge will be imposed. The annual percentage rate, the amount or method of determining the amount of any membership or participation fee that may be imposed as part of the plan, and the payment information described in 1026.40 D5 I and 2 that is required under 1026.6 E2. 4. When more than one consumer has the right to rescind, the exercise of the right by one consumer shall be effective as to all consumers. Notice right to rescind In any transaction or occurrence subject to rescission, the creditor shall deliver 2 copies of the notice of the right to rescind to each creditor entitled to rescind. 1 copy to each if the notice is delivered in electronic form in accordance with the consumer consent and other applicable provisions of the e-Sign Act. The notice shall identify the transaction or occurrence and clearly and conspicuously disclose the following. 1. The retention or acquisition of a security interest in the consumer's principal dwelling. 2. The consumer's right to rescind as described in paragraph A1 of this section. 3. How to exercise the right to rescind with a form for that purpose designating the address of the creditor's place of business. 4. The effects of rescission as described in paragraph D of this section. 5. The date the rescission period expires. C. Delay of creditor's performance. Unless the consumer waives the right to rescind under paragraph E of this section, no money shall be dispersed other than in escrow. No services shall be performed and no materials delivered until after the rescission period has expired and the creditor is reasonably satisfied that the consumer has not rescinded. A creditor does not violate this section if the third party, with no knowledge of the event activating the rescission right, does not delay in providing materials or services, as long as the debt incurred for those materials or services is not secured by the property subject to rescind. The effects of rescission. When a consumer rescinds a transaction, the security interest giving rise to the right of rescission becomes void, and the consumer shall be liable for any amount, including any finance charge. 2. Within 20 calendar days after receipt of a notice of rescission, the creditor shall return any money or property that has been given to anyone in connection with the transaction and shall take any action necessary to reflect the termination of the security interest. 3. If the creditor has delivered any money or property, the consumer may retain possession until the creditor has met its obligations under paragraph D2 of this section. When the creditor has complied with that paragraph, the consumer shall tender the money or property to the creditor, or where the latter would be impracticable or inevitable, tender its reasonable value. That the consumer's option tender of payment may be made at the location of the property or at the consumer's residence. Tender of money must be made at the creditor's designated place of business. I'm seeing how to use tender of money. thought it would be tender of payment, but if the creditor does not take possession of the money or property within 20 calendar days after the consumer's tender, the consumer may keep it without further obligation. For the procedures outlined in paragraph D 2 and 3 of this section may be modified by court order. E. Consumer's waiver of right to rescind. The consumer may modify or waive the right to rescind if the consumer determines that the extension of credit is needed to meet a bona fide personal financial emergency. To modify or waive the right, the consumer shall give the creditor a date, written statement that describes the emergency, specifically modifies or waives the right to rescind, and bear the signature of all the consumers entitled to rescind. Printed forms for this purpose are prohibited. F. Exemption transactions. The right to rescind does not apply to the following. 1. A residential mortgage transaction. 2. A creditor plan in which a state agency is the creditor. And this is a reading from 12 CFR 1026.15, right of rescission. To get this copy, y'all can just drop y'all email and we'll send it. Peace and thank you.